Hi, everyone. This is a short video on the criminal justice process in the United States. And I'm doing this video because in this course, Legal Communication and Analysis, and in your other courses, you've been focusing primarily on civil proceedings, not on criminal proceedings. But because the office memo assignment involves a criminal proceeding, and because you won't focus much on criminal law until next semester, I thought it would be a good idea to look at the basics of how criminal proceedings work and how they differ from civil cases. So let's start with that premise and talk about the difference between civil and criminal proceedings. So we'll start with civil cases first. So first of all, civil cases are brought to vindicate individual interests. For example, the plaintiff in a civil case may be seeking money damages for injuries that he or she suffered in some sort of accident. By contrast, in criminal cases, a criminal case is brought to punish someone for violating criminal law. So civil action, vindicate individual interest; criminal action, to punish someone. Second difference, so in civil actions, those can stem from various sources of law. So for example, a civil claim can stem from a common law cause of action, such as, tort law is a good example. There are torts, intentional torts, for example, that are common law based. Some civil actions can stem from statute. In Indiana, for example, if you have a neighbor who's being overly noisy and that is interfering with your ability to enjoy your property, you can sue that person for a cause of action in private nuisance. And that cause of action is governed by a statute in the Indiana Code. So by contrast, all criminal proceedings are governed by statutory law. So if you're going to, if the prosecution is going to charge somebody with, say, burglary, for example, you'd have to go to a statute to initiate that prosecution. In Indiana, for example, if you're going to prosecute somebody under state law for violating the laws against burglary, you'd look to the Indiana Code, where there is a statute that lays out the elements of burglary. And then the final difference between civil and criminal proceedings is that with a civil action, that can be brought by anybody. It can be brought by a person or a corporation or a governmental body, depending on the circumstances. By contrast, the person filing the action in a criminal prosecution is usually a prosecutor acting on behalf of the government. So in a state criminal prosecution, the prosecutor would be filing the charge against the defendant on behalf of the state. In a federal prosecution, the prosecutor would be filing the charge on behalf of the United States. So those are the three main differences between civil and criminal proceedings. Next, I want to talk about the types of criminal offenses, specifically the level of criminal offenses. And when I say level, I'm talking about the type of punishment you might be facing for violating a particular provision of criminal law. So first type of criminal offense is an infraction. This is the lowest level of criminal offense. It's usually we're usually talking about a very minor offense. Jaywalking is one that comes to mind. And typically, if you commit an infraction, you're just going to get a ticket, and the punishment you'll get is usually a fine of some sort to pay. So if you have if you get caught speeding, you usually get a citation, a ticket from the police officer who stops you, and then you can go into court and contest that. But if you don't, you just send in a payment of a fine. Next type of criminal offense is a misdemeanor. So this is a more serious type of crime than an infraction, but usually still a minor crime. In Indiana, for example, the possession of a small amount of marijuana is considered a misdemeanor. And for violating a misdemeanor statute, you can get some jail time, although it's not likely to be lengthy. You could also be required to pay some sort of fine. And I think in some cases, depending on the jurisdiction, you could be ordered to pay restitution to the victim as well. And then finally, the most serious level of criminal offenses are felonies. So we're talking about major crimes here, such as murder, robbery, rape, in some instances assault, depending on how the assault's committed. Arson is usually a felony. With felonies, you're usually going to get jail time. That's going to be lengthier than it is for jail time for a misdemeanor. It will, of course, depend on the type of felony that you commit. So murder, if you commit murder, you're going to get a lot of jail time. If you commit something like felony drug possession, you're probably going to get less time in prison. So now I want to talk about how a criminal case proceeds from arrest through court to conviction to possibly appeal. Basically 5 steps that I want to talk about in more detail. The first step usually is that the prosecution brings charges against the individual and arrests that person, although there are some circumstances where the arrest occurs first. I'm not going to go into detail when that is. You'll talk about this probably in your criminal law class. Second step are pretrial proceedings. Third step is if the case doesn't get resolved in pretrial proceedings, it goes to trial. If there's a conviction, then the next step is to have a sentencing hearing. And then finally, the defendant is usually going to have the right to appeal the conviction and the sentence. So let's focus on the charges first. So if a defendant hasn't already been arrested, the first step that happens is that the court where the criminal charge has been filed against the defendant will issue a warrant for the defendant's arrest. And this only happens after the court has found probable cause that the defendant has committed the crime. In other words, I guess a short way of describing probable cause is, would a reasonable person believe that the defendant has violated the provisions of the criminal statute in question? The charge is filed in court, and it's detailed in a document that's either called an information or an indictment. And I'm not going to talk about the distinction between the two because it's really not important at this stage. But the information or the indictment just sets forth the allegations against the defendant, describes the criminal statute that the defendant has violated, and discusses why the defendant has, under the facts of the case, violated that statute. It's usually a pretty brief document depending on the type of crime. Sometimes if it's like a case involving complex white-collar crime, the information or indictment could be pretty lengthy in laying out the allegations against the defendant. So this is essentially the equivalent of a complaint in a civil case. Step 2 are the pretrial proceedings. Usually what's going to happen is after the charge is filed and the defendant is arrested, there will be an initial hearing where the defendant has the charges explained to him or her in court. Usually the defendant is going to enter a plea of not guilty. At least that's a preliminary plea. And then the court sets what's called an omnibus date. We'll talk about what an omnibus date is in just a moment. Usually, and this is going to happen roughly 90+% of the time, the prosecution and the defendant are going to engage in some plea negotiations where the defendant will be offered the opportunity, usually, to plead guilty to a lesser crime than the one that the defendant's been charged with, that carries a lesser punishment than the crime that the defendant has been charged with. And this is how the vast majority of criminal cases are disposed of in the United States. As I said, it's roughly above 90% that a plea occurs and the parties reach a plea agreement. If the parties do reach a plea agreement, then what happens after this, instead of a trial, is a plea hearing where the trial court verifies with the defendant that the defendant did commit the crime to which the defendant has pled guilty to. If no plea agreement has been reached, what happens next is called an omnibus hearing. And this happens on the omnibus date. And essentially what an omnibus hearing is a hearing in which any outstanding issues that are in the case are taken care of. So for example, if one of the parties has a pretrial motion, such as a motion to prevent the admission of certain evidence, that will be presented at the omnibus hearing. So the court tries to resolve any remaining issues in the case before the case goes to trial. And then there's the trial. So this is what happens if the prosecutor and the defendant don't reach a plea agreement. And at trial, the burden is on the prosecution to establish the defendant's conduct meets the elements of the charged crime. And that conduct has to satisfy those elements beyond a reasonable doubt. That's a high standard of proof. And criminal cases are normally tried to a jury unless the defendant waives that right. This is a constitutionally guaranteed right for the defendant, but the defendant can waive that right. And if the defendant waives the right to a jury trial, then the case is heard in a bench trial just before the judge. If the defendant is convicted or pleads guilty, the next stage is a sentencing hearing where the judge, not a jury, but the judge determines the appropriate punishment for the defendant. And of course, this is based on the level of offense that the defendant has committed. But the parties are usually given the opportunity to introduce additional evidence that may indicate that the sentence should be at the high end of the possible range of sentences that the defendant could receive. And then the defendant, conversely, is allowed to present evidence that would perhaps indicate the defendant should receive a lighter sentence than at the lower end of the sentencing range. And as I noted, this decision is usually made just by the trial judge. But in certain criminal proceedings, the jury is the main decision maker. So for example, in Indiana, in capital cases where the defendant has been charged with a capital offense and stands the possibility of being sentenced to death, the jury makes the initial sentencing recommendation to the judge. So the jury hears the evidence from both sides as to why or why not the defendant should receive a death sentence, and then recommends to the trial judge what that sentence should be. And then the judge is can either follow that recommendation or conclude that the jury should not have reached that decision and reach the opposite decision. Other jurisdictions don't necessarily do this. In some states, the judge alone determines the death sentence. But usually in capital cases, a jury is involved in the decision-making in some way. And then finally, if the defendant is convicted and sentenced, the defendant normally has the right to appeal the conviction and or the sentence to a higher court. And usually that's the jurisdiction's intermediate appellate court. So in Indiana, if you're convicted of a crime and you want to appeal that conviction, you usually appeal to the Indiana Court of Appeals. But in certain limited instances, you're going to skip the intermediate appellate court and appeal directly to the court of last resort. So you may remember in the early classes of this course, I mentioned that in capital cases, if you're convicted of a capital crime and sentenced to death, you appeal directly to the Indiana Supreme Court instead of appealing to the Indiana Court of Appeals. Now, if the defendant is acquitted, the prosecution can't appeal that. And that's based on a prohibition against what's called double jeopardy. That's guaranteed in the federal constitution. It's also guaranteed, I think, in pretty much every state constitution as well. But in limited instances, the prosecution can appeal an adverse decision in a criminal case. And usually this happens, let me use Indiana as an example. In circumstances where a charge is dismissed against a defendant, in certain circumstances where that dismissal occurs, the prosecution can appeal that dismissal. So for example, if the trial court determines that the evidence against the defendant was illegally seized by the police, thus violating the defendant's rights under the Fourth Amendment to the Constitution to be free from unreasonable seizures, searches and seizures. That sort of decision can be appealed by the prosecution if it results in a dismissal against the defendant. So that wraps up our discussion of criminal justice proceedings. I hope you found this informative.